The U.S. Supreme Court has agreed to hear the U.S. Patent and Trademark Office's appeal of a federal circuit ruling that allows individuals to secure registration of a trademark using the name of living persons without that person's consent. That's what we'll be discussing on this installment of the briefing by Weintraub Tobin. I'm Tara Sattler from Weintraub Tobin, and I'm here with my co-host, Scott Hervey, who is also a partner of mine. Scott, I'm excited to be here with you today.
Yeah, me too, Tara.
Last year, the Federal Circuit overturned a decision from the USPTO Trademark Trial and Appeal Board in which the USPTO refused to grant a trademark registration for the mark Trump Too Small for use on t-shirts. The USPTO refusal was based on Section 2C of the Lanham Act, which requires the USPTO to refuse registration of a mark that consists of or comprises a name, portrait, or signature identifying a particular living individual except by his written consent.
After the TTAB affirmed the trademark examiner's refusal to register, the applicant, Steve Elster, a lawyer, by the way, appealed the matter to the Federal Circuit. And there, Judge Timothy B. Dyke held for a unanimous panel that the government has no legitimate interest in protecting the privacy of President Trump. Basically, the Federal Circuit overturned the TTAB's refusal to register on First Amendment grounds.
Elster argued that the phrase was political criticism and accordingly protected by the First Amendment. The Federal Circuit agreed and overturned the USPTO's refusal to register. The USPTO appealed the matter to the Supreme Court and suspended applications on all pending trademarks that are critical of public or government officials until the Supreme Court weighs in on the issue. In its petition, the USPTO argued that more clarity is needed than the Federal Circuit provided.
In its petition to the Supreme Court, the Trademark Office argued that enforcing the Federal Circuit's decision conflicts with the plain language of Section 2C of the Lanham Act.
And the USPTO also argued that Judge Dyke's reasoning was twisted because handing out trademarks that include political criticism of notable figures would actually limit that kind of speech. Specifically, the office stated that it is the registration of marks like respondents, not the refusal to register them, that would chill such speech.
That is correct, because as you know, a trademark registration is essentially a grant of monopoly over the use of a particular mark in connection with specific goods or services. So if the applicant was able to get a trademark registration for Trump Too Small for use on t-shirts and other things like bumper stickers, that would prevent other people from doing the same, and that would chill political commentary. So this is an interesting issue for the Supreme Court. Is a Section 2C refusal to register the same thing as a government restriction on free speech? And if the Supreme Court were to affirm Judge Dyke's decision, it could lead to even more interesting issues down the road. For example, trademark examiners would have to make a decision about whether a particular trademark expressed protectable speech under the First Amendment. That isn't the most straightforward analysis in the legal world. And in any event, this is definitely not something that I think a trademark examiner should be making a call on. But this is really an interesting case. I'm glad that the Supreme Court granted cert, and we're definitely going to be watching this going forward. Tara, you have any thoughts?
I wonder whether the Supreme Court is going to make a distinction in public figures versus private figures like we have that exists in some First Amendment law. And that seems to apply to this specific case at hand. And I wonder if the Supreme Court will think that that would be a good metric to set and apply to perhaps trademarks as well.
Yeah, I mean, it's interesting. It would have to be a case, though, for Congress to amend the Lanham Act, because the Lanham Act does not, or Section 2C of the Lanham Act does not delineate, right, between a public person or a private person. It just says persons. So it would have to go, Congress would have to I think Congress would have to make that distinction and change the law in order for that to happen. I don't know that the Federal Circuit or any court has the right to rewrite legislation where it's not vague. But we'll see. I've been wrong on my calls before here, so we'll definitely see what happens. Tara, thanks for bringing this to our attention.
Yeah, it's great to be here, Scott.
Thanks for tuning into this installment of The Briefing by Weintraub Tobin. Hope you enjoyed this episode. If you found it interesting, well, we've got over 100 more. But please remember to subscribe to our podcast and to our YouTube channel. Thanks.